Welcome, everyone. We are pleased that you have joined us for today's webinar entitled Recent Developments in 60-Day Rollovers. The webinar will last approximately 15 minutes, and at the end, you will be given an opportunity to receive supporting materials by email, free of charge to you. You will also be told how you may email questions related to today's content to the presenter. Today's presenter is Linus Sugis. Linus worked for a Chicago-based insurance company in various roles, including Director of Advanced Sales and as Chief Marketing Officer. He ran and sold a successful estate planning law practice in Franklin, Tennessee. Linus also writes the publication Think About It, founded by life insurance industry guru Steve Lineberg, and Linus regularly speaks at industry events. His new book, Sell Out, The Busy Entrepreneur's Guide to Transferring a Closely Held Business, written together with a CPA and a business broker, is now available on Amazon.com. Linus will draw on his legal, tax, and life insurance background and practical experience for today's webinar. And here he is.
Thanks, Jennifer, and good morning or good afternoon to everyone on the call. We're going to talk today about some recent developments that we've been given with regard to 60-day rollovers. The developments really fall into two categories. Category number one has to do with 60-day rollovers generally, and then the second category really has to do with the potential for a surviving spouse to complete a 60-day rollover on an inherited account where the surviving spouse is not necessarily the beneficiary. So we're going to talk about those in a minute. But before we do, we're going to decide on the topics or the topic that we'll cover on one of our upcoming webinars. Just so you know, the regulations on business income taxation as a result of the Tax Cut and Jobs Act, the proposed regulations are scheduled to come out here in the next week or so. And it seems likely that our very next webinar, the one that we'll do in September, will be on that topic. So we're going to pick the topic for the following month. At least that's the plan as of today. And the choices are the answers that we don't know the answer to here at Advanced Underwriting. The second choice is the most asked questions that we get about Medicaid planning. And then the third potential topic is 10 Shades of Gray, the tax risk continuum. That's about helping clients evaluate the kinds of tax risks that are associated with various ideas that we might present. And so at this point, if we can launch the poll. The poll is open. Please go ahead and vote for your preferred seminar topic, which will probably be presented in October. We'll give you just a few seconds to complete. If you'd participate and vote, that would be great. I'll be quiet and let you finish it up. If you haven't yet voted and want to, please go ahead and do it in the poll portion of your control panel for the webinar. All right, let's close the poll. And the overwhelming choice, probably because of the title, is 10 Shades of Gray. It won't nearly be as interesting, I suppose, as the novel, but in any event, we will talk 10 Shades of Gray during probably the October webinar. Thank you all for participating in the poll. All right, so let's go on and let's talk about 60-day rollovers and some of the things that have happened there in the last little bit. So let's talk about rollovers generally. The IRS, Congress, and the president all want to encourage people to save for retirement. And as part of that saving for retirement, it's got a carrot and stick approach to qualified plans. The carrot is, of course, the ability to make tax-deductible contributions to many of these qualified accounts, employer accounts, or IRA accounts. In a lot of cases, the contributions are tax deductible. And the ability to roll over monies from an employer-sponsored account to an IRA or from one IRA to another, the ability to do that rollover on a tax-free basis is another kind of carrot that Congress and the president put out there. Now, there's also a stick, and the stick is that distributions from the account are subject to income tax generally, and they're also subject, if they're taken early, to a penalty tax, an extra 10% penalty tax. And so carrot and stick approach to saving for retirement there by the government. But the government does allow for rollovers. The kinds of rollovers that it allows are from one kind of employer-sponsored qualified retirement account to another, from one employer plan to an IRA, from one IRA to another, and in a lot of cases from an IRA, a traditional IRA, to an employer plan. Those kinds of transfers are generally allowed, or those kinds of rollovers are generally allowed on a tax-free basis. Now, there are two kinds of rollovers. You can either make the rollover direct, meaning that the money goes directly from one custodian or trustee to another custodian or trustee without the client putting the client's hands on the money during the process. And I got to say, where you've got a choice, this tends to be the cleanest way to do it. If the client doesn't handle the money, it's usually pretty seamless, and the rollover happens and it's tax-free, and everybody's able to move on pretty easily. Where the client starts handling the money, things tend to get a bit more dicey, but it is a valid way to perform a rollover. Funds can be sent by the custodian or the trustee of the qualified account to the client, and so long as the client redeposits that money within 60 days within another qualified account, that's generally a tax-free event. And that kind of rollover is sometimes called the 60-day rollover, sometimes referred to as the indirect rollover. And so we're gonna talk mostly about indirect rollovers today and some of the developments there. So what is a valid 60-day rollover? A valid 60-day rollover, first of all, has to be an eligible rollover distribution from an employer-sponsored plan or an IRA that is deposited into another eligible retirement plan or IRA within 60 days of the taxpayer's receipt of the distribution. Now, Jennifer and I get a lot of calls from financial professionals where the question is, well, what does it mean that the client received the money? Did it is coming in the mail? Is it when the client opened the mail? Is it when the client actually did something with the check? And those kinds of questions tend to be questions of fact that the IRS will only let you know about on the backside. But the technical answer is that the 60 days starts from the time the client receives the money. And all of us who are on this call understand that the IRS tends to interpret these things in favor of imposing tax as opposed to not imposing tax. And so the earliest date that you can say that a taxpayer has received the money tends to be the date the IRS goes with. And so if the taxpayer fails to complete the rollover within the 60-day deadline, any pre-tax money that the taxpayer received is technically subject to both income tax and also the 10% extra penalty tax if someone's younger than 59 and a half. And so if the rollover is botched, that's the potential penalty. The good news for us is that the IRS has granted leniency in certain situations, and we're going to talk about those types of situations now. So there is a section of the code that says that the IRS may grant a waiver for a failed rollover, and the IRS may decide to say that the rollover was good, even though it didn't meet the technical requirements of the 60-day rollover. And the IRS has said that it will grant a waiver in one of three ways. First of all is qualifying for an automatic waiver. We'll talk about that in a second. Another way is through the self-certification process. That's relatively new, and we'll talk about that too. And then a waiver that's obtained through a private letter ruling. And we will also touch base on what that means for our clients. So let's talk about automatic waiver first. And automatic waiver is the one, if we've got a choice, that we want to be able to point to because nothing special needs to be done. If any of these conditions have been met, then if the conditions for the automatic waiver have been met, nothing needs to be done. No private letter ruling, no self-certification. The waiver is automatic if all of the following conditions apply. And it's really, if you look at these four conditions that are listed on this slide, they have to do with error that are all on the custodian side. This is not anything that the client did to fail to make the 60-day deadline. This is what the financial institution did to fail to make the 60-day deadline. And so if the financial institution failed on its end, and these conditions are met, the client gets an automatic waiver of the 60-day deadline, and the 60-day and the indirect rollover is good, even though the deadline was not met. So it's going to be relatively rare for us to have to deal with automatic waiver. So what if the client has done something, or the client has failed at its end, or these four conditions are not met? Well, the good news there is that in 2016, relatively recently, the IRS approved another method for seeking relief from an invalid indirect rollover. The IRS said that if the taxpayer could self-certify that one of 11 conditions had been met, the taxpayer could tell the plan custodian that the rollover was good and the custodian should accept the funds. And the conditions are listed on this slide and the next. They have to do mostly with, well, again, financial institution error, but a distribution check was misplaced and never cashed. That happens sometimes during our calls. Damage to the taxpayer's primary residence, death in the family, serious illness, incarceration, post office error, and then some other technical kind of requirements. The IRS has given the taxpayer kind of a self-certification letter that can be used, a sample letter. We've got a copy of it here on your screen. You can see what the letter says. The letter has on it the 11 kind of self-certification conditions that can qualify the taxpayer for self-certification. It's a check-the-box approach. And the idea is for the taxpayer to provide this letter to the custodian. In a lot of cases, it'll be an IRA custodian saying to the custodian, look, I'm outside of the 60-day deadline, but you can still accept these funds because the IRS has allowed for an exception to the 60-day deadline for these conditions. And then the taxpayer checks the box and tells the IRS which of the conditions are applied. And so that's good news. It makes the process of getting outside the 60-day window better for a lot of taxpayers. Well, what happens if the taxpayer does not qualify for those conditions? Then the answer is The taxpayer is stuck with seeking a private letter ruling if the taxpayer wants to avoid taxation on the failed rollover. Private letter ruling is basically the taxpayer asking the IRS to make an exception or to make a particular ruling based on the taxpayer's particular circumstances. The downside of the private letter ruling process is that it's expensive. It costs 10 grand to get started, and in the real world, it probably costs a fair amount more than that when you work in the cost of hiring professionals to kind of guide the request through the IRS process. And the IRS has tended not to be particularly lenient in deciding that certain kinds of conditions qualify for an exception to the 60-day rollover. In fact, a few years ago, it was common for the IRS to routinely deny requests for waivers of the 60-day rollover period. And there are plenty of examples where the private letter rulings, where the taxpayer got bad advice from tax professional or somebody else, and the deal was that the rollover was going to fail under those circumstances because the private letter ruling was going to be denied. Now, in the more recent past, the IRS has been more lenient about those kinds of conditions. So that starts with private letter ruling 2018-22033, which is really kind of the centerpiece of today. Taxpayer separated from her job, wanted to roll her funds into an IRA in February of 2017. She deposited the lump sum that she received from the qualified plan into an account that she and her spouse jointly owned. In late August, the taxpayer's spouse contacted the tax professional about rolling the funds into an IRA, and the tax professional said, "Hey, you missed the 60-day rollover period." The husband decided that the husband had thought that because of there was an actual deadline of the calendar year instead of the 60-day deadline, and the taxpayer went to the IRS and asked for relief, basically saying, "Hey, my husband screwed up. I got bad advice from my husband. Please allow me to roll over these funds, even though they are late." And the IRS, in this case, granted that relief, and that was a surprise because it's contrast to some of the recent letter rulings that the IRS claimed that ignorance of the law was no excuse, and that that kind of analysis would not have succeeded in the past. That kind of fact situation would not have succeeded in the past for rollover. So that's that case. So it's good news. The private letter ruling indicates the IRS is probably going to be more lenient about deadlines for 60-day rollovers. The second thing that we wanted to talk about today, and we'll talk about this briefly, is spouse as beneficiary of an inherited IRA. Most of you on the call know that spouse has a lot of choices with regard to inherited IRAs. One of the most valuable choices surviving spouse has is the ability to roll over the inherited qualified account, IRA or otherwise, into her own IRA. This kind of rollover is something that is not given to other kinds of beneficiaries. It's only surviving spouse who has this power, and so that kind of procedure really gives surviving spouse a powerful advantage over other beneficiaries. Well, in a lot of cases, our clients, because of misunderstanding or other reasons, may not name surviving spouse directly as the beneficiary. Maybe it's an oversight, maybe it's some other reason, but in some cases, estate or surviving or some kind of trust is named the beneficiary of the IRA. And in those kinds of circumstances, the worry is that the surviving spouse's ability to roll over the inherited IRA account, where a trust or estate is the beneficiary, into her own IRA is lost. The good news is that the IRS has said that you still may be able to preserve, in certain cases where a trust or estate is the beneficiary, you still may be able to preserve the surviving spouse's ability to roll over the IRA money into her own, the inherited IRA money into her own IRA. One such example is Private Letter Ruling 2011-25047. There, IRS said that trust as beneficiary is usually not eligible to have surviving spouse to roll over the money into her own IRA, except if the surviving spouse had the sole authority to pay the trust proceeds to herself as both trustee and beneficiary. She could accomplish spousal rollover of the inherited IRA amount. And in general, that would be accomplished by 60-day rollover. The money would go from the inherited IRA to the trust. The trustee of the trust, who is the surviving spouse, would take a distribution into her own hands, and within 60 days of the custodian having sent the money to the trust, the surviving spouse would deposit the money by 60-day rollover into her own IRA. So that was kind of the logic of the 2011 private letter ruling. It required a fair amount of control by a surviving spouse. There's also a 2017 private letter ruling, which is made reference to on the slide, where it was a little more tenuous about the surviving spouse's control over the revocable trust. The estate was the beneficiary, the revocable trust was the beneficiary of the estate, and the surviving spouse was one of the beneficiaries of the revocable trust. So the connection was a little more tenuous, but the surviving spouse and the other trust beneficiaries acting together worked to convince the IRS that the surviving spouse would have enough control to be able to perform or a rollover of the inherited IRA account, even though the estate and not the spouse was the beneficiary. So that was really good news, really strong news, really flexible news with regard to being able to conduct a rollover. Likewise, and in 2018, another private letter ruling, the decedent had a governmental 457B plan with the estate as the beneficiary. Surviving spouse was the sole beneficiary of the estate, and the IRS allowed the surviving spouse to roll over the inherited governmental 457B funds into the spouse's own IRA, even though the estate was the beneficiary. So to wrap this up, let me make the big observation that the IRS has been more lenient recently. It's been more lenient on two fronts. First of all, with regard to 60-day rollovers. Secondly, with regard to rollovers of spousal inherited funds where the spouse wasn't directly named the beneficiary of the qualified account or the IRA. That's good news for us. It allows some flexibility for our clients. And so if you run into those circumstances where you're trying to work through a spousal continuation or 60-day rollover, and you're worried that you aren't quite completely conforming with the rules, give us a yell. We're glad to visit you with you about that, help you think through the issues in light of these case developments, and help you sort it out so that you can serve your client better in these circumstances. And at this point, I'm going to turn the program back over to Jennifer. Jennifer?
Thanks, Linus, and thank you for joining us today. As a reminder, if you would like to receive supporting materials, feel welcome to email me at asktheexpert@advancedunderwriting.com. Again, that's asktheexpert@advancedunderwriting.com. You may also email questions related to today's webinar. Finally, for more information about the services that advanced underwriting consultants offer, including phone consultation and newsletter licensing, feel welcome to contact me at 615-224-1291. Again, that's 615-224-1291. Thanks again, and best wishes for continued success.